Hi everyone, and welcome to today's Cose WebEd webinar. My name is Sean Turner. I am the Content Director here at the Greater Cleveland Partnership, and I'll be your webinar host for today. Our topic is a good one. It's how to use intellectual property to grow and protect your business. Our guest today is Mark Ginto. He's an intellectual property attorney at McDonald Hopkins Cleveland office. Before we get to Mark's presentation, though, I do have a couple of housekeeping items that I want to go over. First of all, we're not necessarily going to hold questions until the end. We want this to be interactive. We want it to be conversational. So we are going to take a couple of opportunities during Mark's presentation to canvass you all in the audience for questions. So with that in mind, as you're listening, feel free to type in the questions that you might have and type them into your control panel and submit them. They're only going to be visible to me. I'll relay those questions over to Mark after I've collected them. And we do hope that you take advantage. This is a really unique opportunity for you to get questions answered on a very kind of complex topic and subject and get them answered by an expert. And the even better part of that deal is that Mark has assured me he's not going to charge anyone an hourly rate for asking anything. So please, get those questions in. Secondly, and this is just a disclaimer because the information we're going to go over today is legal in nature, the information that we're providing on this webinar today is general in nature and may not apply to a specific factual or legal circumstance. An attorney and client relationship should not be implied simply by attending this webinar. Nothing in the webinar today is intended to substitute for the advice of an attorney. Therefore, if you do require legal advice, please consult with a competent attorney licensed to practice in your jurisdiction. The choice of a lawyer is an important decision. It should not be based solely upon advertisements. So McDonald Hopkins invites you to get in touch with them, and they welcome your calls, your letters, and your email. Contacting them or attending this webinar does not create an attorney-client relationship. Past results afford no guarantee of future results. Every case is different and must be judged on its own merits. And with all of that said, I am going to go ahead and turn things over to Mark now so we can get our webinar started. Mark, the floor is yours.
Thank you, Sean, and welcome everybody. As Sean said, my name is Mark Ginto. I'm an attorney here at McDonald Hopkins in the Cleveland office. We're a general practice firm and with a lot of business clients and do primarily full services to business. That said, we'll jump right in. To start with, just the goal of this webinar is to help you strategically protect your ideas, brands, and assets, particularly through the use of intellectual property. Now understand we have a diverse audience here, each having your own different unique challenges to your unique businesses. Most of you, though, probably have some opportunities to seek intellectual property protection and to help service your customers on their demands and their needs. And we also have to keep in mind that your competitors are likely to be trying to leverage intellectual property to their benefit. With all that, we're going to go over a few broader topics. First, just the different types of intellectual property, what we really mean when we say intellectual property, and beyond what you hear on Shark Tank or what you see in the news, just somebody saying IP, patent, trademark, and all the other different terms. We'll take a little deeper dive into patents and discuss a little bit, what it takes to get a patent, what you can do with a patent, and what a patent really is. Throughout it, I'll give some practical tips, some take-homes that you can use in your business and hopefully use to help you guide and make decisions to meet your overall goals of leveraging your assets and getting greater protection to help your business grow. Finally, we will discuss trademarks and take another deep dive into trademarks if we have enough time. As I said, the benefits are, our main benefits to you are going to be to help you identify assets that you can protect in the future for your business, to really help you position yourself and your business for future success. with the ultimate goal of increasing your market share and growing your business. When we talk about intellectual property, there are really 4 different categories that we're referring to. Those are patents, trademarks, copyrights, and trade secrets. Patents protect the overall idea of your invention. Trademarks are your brand identifiers or source identifiers. They're the names you see, like Nike, you see the Nike swoosh, McDonald's, any other famous mark like that. Those are the trademarks that identify a company or who makes a certain product. Copyrights are rights in the expression of your idea. So those are things like songs, audio recordings, books, magazines, articles. It could be software, the software code that your company has, advertisements that your company puts out, and finally, trade secrets. Most famous example there is the Coca-Cola recipe. Trade secrets are basically any information or practices, know-how that you keep within your own company and you do not disclose to the world. We'll start off just touching trade secrets very quickly. I said trade secrets are know-how. Some examples are your customer lists, chemical formulations, pricing, coding practices, really a lot of your internal practices that are not easily discoverable by your competitors, and they give you some competitive advantage over other people in the industry. Importantly, these can last in perpetuity, so they last forever as long as somebody else doesn't come up with or can't reverse your trade secret or have an independent invention on their own. Now, as we discussed, patents are protections over inventions or new ideas. There's some basic requirements to being patents. It seems complicated, but there's really only 3 statutes that we primarily deal with when we try to get a patent. The first requires it to be new and useful. Useful just means it can have any use. As an example, here I have patent 7484328, which is directed to what the patent title is, an insect dissuasion device. It looks like a finger-mounted fly swatter. That had enough utility to be granted a patent. The next part is new. If something's new, and the final step is something obvious. Those are sort of interrelated concepts there that we might need to break down a little bit. And before we get to there, I'm just going to give you an example patent that so you know the parts and pieces of a patent if you were to go up and look up a patent and view one on your own. On the screen, you should see this is a front page of the patent. There's different fields in there. You have your title, inventor, assignee, filing date. You also have the patent number in the top right corner and when the patent was granted. After that, you'll have a detailed description. You'll always have a detailed description and drawings. And finally, it's followed by the claims. Those claims define what an invention is. And that's when you get a patent on the claims. So as an example, this patent could have 10 different embodiments or different versions of a finger-mounted fly swatter, but it's only the version that is claimed in the claims that is covered by the patent. And as we said, novelty is usually the first step in determining whether something's patentable. That means is it new? Has anybody ever done this before? So when you file a patent application with the USPTO, the United States Patent and Trademark Office, they will look at your claims and then they'll look at prior patents or prior publications and see if anybody has ever filed an application or anybody's ever published something similar to what you're claiming. Obviousness is a little different. They can seem similar, but obvious just means that something that whatever you've claimed in your patent is not identical to something previously out there, but it has minor modifications that would be obvious to somebody skilled in the art. So here's an example where on the left we have dog ear protectors made out of plastic bags and a flexible tie in between them. And on the right we have more dog ear protectors that look like a hollow tube with straps both beneath and above the head. The later filed patent is the one on the left, and that was new or novel because the prior version had a hollow solid tube. And the United States Patent and Trademark Office also determined that this was a non-obvious variation over the hollow tube version. For whatever reason, it could be the plastic bag provides some additional benefit where it covers the full ear as opposed to the hollow tube where the portion of the ear hangs out. I'm going to stop here and see if we have any questions on novelty and obviousness.
So, Mark, what are the standards when the Patent Office is judging whether something is obvious, whether something is novel? Is there a test that they apply?
Yes, it's called person of ordinary skill. They use that as their term that they use. Would it be obvious to somebody of ordinary skill in your industry? So if your company does software, they're going to look at what would a typical software engineer know in this industry. And if they viewed, if we gave them these pieces of prior art, which old textbooks, old patents, would they think your invention is just an obvious variation based on the knowledge that they have? Novelty, then their test is, novelty is more stringent. It has to be the exact same or very similar to what is already out there in the prior art. So if you file an application with a chair with 5 legs on it, and the USPTO doesn't have an example of a chair with 5 legs on it, then your invention would be novel. But it might not be, or it might also be obvious, which would prevent you from getting a patent.
And if there's, if it fails one of those tests, what are the, is there an appeal process, or what would be the next step?
Yes, when you're working with the USPTO, there are appeal processes, but the more common approach is the USPTO will issue what's called an office action. It basically tells you whether or not they're going to grant your patent, and if they decide, and if the office action says that they're not granting your patent, it'll give you some reasons why it's not going to be granted, and it'll lay out the rejection, whether it's novelty, obviousness, or some formal requirements. And then you have an opportunity to respond to the patent office, respond to that office action. And that could go on for many years. I've had cases where it's been 15 years dealing with the patent office, getting an office action, then you respond to them, then you get another office action, and you respond to them until you can finally work and figure out what can be patented. I also want to mention a few bars to patentability that often come up, especially in corporations. The 2 first ones are on-sale bar and public use bar. Both of them have a year requirement where if you offer, for example, the on-sale bar, if you offer a product for sale, you have to file a patent within 1 year of that first offer for sale, or you are barred from receiving patent protection by the United States. The public use is similar. If you use that invention in public, then you have 1 year to file a patent application. Otherwise, you're barred from receiving patent protection. That's a little different in many other countries. Most foreign countries have absolute novelty requirements, which means if you offer to sell somebody your invention, and then the next day you file a patent application, you are then barred from receiving any patent protection. It's a little harsher in the foreign countries, but so it's very important. This is a very important point if you're going to seek patent protection, to be diligent in when you file and know where you're going to file. Now, I know a lot of my clients struggle with this when they're dealing with their customers, and the client might have a particular solution that they're thinking of or a product that they're about to launch, and customers often try to get as much information as they can. Some tips that I usually give them are, if they're ever in doubt on whether they've filed protection on something, always err on the side of caution. And some examples of things you can say is, I think I have a solution here, but I want to go back to the office and make sure it's right. I don't want to give you any wrong information. Or, we might be able to solve your problem. Let me give you a call in a week. Another point I want to make too is be careful when you're crowdsourcing. So this is when you're using any kind of crowdfunding website where you put your product up and offer somebody, hey, if you invest in my product now, in 5 years, or whenever it's feasible, I'll give you a discount, or I'll give you a free, some free product in the future. That could be a potential bar to receiving your patents. I would caution you and advise you to look into getting a patent protection before you post on any one of those crowdfunding websites. Now with that, I want to discuss what you can actually do with the patent once you get it. It's great to have. You'll get a nice copy from the patent office that looks great. You can put it on your wall. But more practically, you can prevent other companies from coming in and making, using, or selling that invention that you have and the invention that's defined in your claim. This could theoretically, or this could actually keep competitors completely out of the market. It also opens the door to the possibility of licensing your invention to other companies. And as you progress, as your company progresses, you're going to look to build a patent portfolio around your products that each patent might be an incremental benefit, but as they build up together, they could add great value to your company. It's the type of thing that investors will look at. If you watch any television show like a Shark Tank, one of their first questions is always, what does your patent portfolio look like? First is non-disclosure agreements. These are essentially agreements to share information with somebody outside of your company. When you have a non-disclosure agreement in place, this can prevent that 1-year bar from public disclosure or on-sale bar from triggering. They're very important documents that if you are sharing any of your proprietary information, you will want to have one of these in place, or at least contact an attorney to see if you need one. They'll define what you and the other party can do with the information you share, and they also might define who owns the property that comes out of your agreements or your transactions. Important part here too that clients often run into is management might understand what an NDA is, the president might understand that we need NDAs, but it's not always coordinated down to the sales team. So I would urge you to just reiterate to your sales team to always check if there is an NDA. Even if they think, we've been doing business with company X for 20 years, of course we have an NDA. That's not always the case. Joint developments are a similar kind of agreement where you and another company agree to jointly develop some product or idea. Again, it's going to define who owns what, who owns the assets. It might define, say, our invention, I'm going to own the invention for product X in this market, and you get it in another market. Again, it's something that if you ever are developing a product with another company, you certainly want to have one of these in place so each of you understand your right. Licensing, you're probably all familiar with. There are different ways to structure these, but essentially you give one party, you grant another party or somebody else the right to make, use, or sell your inventions. And in exchange, they'll give you some kind of monetary compensation. Any questions on these kind of agreements before I move on?
Mark, one question that we have that's come in is, you mentioned earlier that you had a one case that went for several years. What is the typical time frame for applying for a patent and getting all of this right?
There are many factors that can come into play. I'll say I think 3 to 5 years might be typical at the USPTO right now. It changes often as the law changes, and it can vary greatly depending on what field, what type of invention you have. Software, I think, tends to be a little longer, and mechanical inventions, pure mechanical inventions, tend to get granted a little quicker. Typically, when you file a patent application, it's usually 18 months before the patent office even corresponds or says anything back to you. And I will say, the way somebody once told me was, if you file a patent application and it's granted without you getting an office action or out getting any rejection, it's a lot like buying a house. If your first offer is accepted, that means you probably could have got a little better of a deal. So if your first set of claims are granted by the patent office, that means you may have been able to get a little bit of broader coverage, broader protection. So there are different strategies, and there's different reasons why the time frame might be different. We still have some time, so I'm going to jump into trademarks. Trademarks are used to identify your products or your services. They're used to identify the source of who makes them. They're used to build goodwill with your consumers and ensure quality when your consumers pick up a product. When you're using trademark, you've probably seen the TM or the R with a circle around it. TM means that you're using something as a trademark, but you have not registered it with the U.S. Patent and Trademark Office. The R with the circle means that you have a registered trademark. Once you register a trademark, you get stronger rights, a little broader rights, and you get rights to enforcement and damages that aren't available for an unregistered mark. As we said, the function of the trademark is really to identify the source of your product and to try to build goodwill and brand awareness with your consumers. Importantly, trademarks are, you require use in the US. You have to have actual use. An example, a local example is the Chief Wahoo logo. There's lots of debate on whether or not that will be used in the future. If the Cleveland Indians stop using that mark on any kind of product, then they could lose their right to that trademark, which means anybody out there can take that logo and use it, put it on t-shirts and sell it without any fear of the Indians stepping in. Another key aspect in trademark law is to make sure that you're using it properly. There are lots of famous marks that have come and gone, and lots that are just common words now that aren't associated with any brand. A few of these are escalator, laundromat, videotape, aspirin, linoleum. These are all former trademarks that died because they were not used properly, or they became so generic that people stopped associating them with a brand. If you remember, a few years ago, there was a television jingle that came out, "I'm stuck on Band-Aid brand because Band-Aid stuck on me." The company that makes Band-Aid brand adhesive bandages identified that there was a risk that they might lose their trademark in the their rights in the trademark Band-Aid. So they came up with that jingle to say Band-Aid brand and clearly identify that Band-Aid is a name of their brand of adhesive bandages. Here's a quick test for proper use. And again, I'll let you look at this in the video or the slides afterwards. I just want to touch on a few key points before our time runs out. So here's an example of how to use and how not to use a trademark. An incorrect use would be, we make the Mondo widget, or we make Mondo widget. Here, you're not identifying, you're using Mondo widget as an adjective, you're using it as the noun. So below it, we see here we make Mondo widget widgets. So that's identifying we make a certain type of product called widgets, and our brand is Mondo widget. Right below that, we have an example of using when proper and improper usage of possessive. The incorrect usage, Mondo widget smart tech. So again, you have a noun that you're saying possesses some feature, and the correct use is Mondo widget with smart tech. Here's just some other examples of usage of different trademarks. Some that you may recognize as trademarks, some that you may not. I know Kleenex tissue there and Band-Aid are two examples that often get used improperly by consumers, and both their companies go to great efforts to reinforce that they're actually trademarks and they're branded. Another recent example, Velcro, that's a trademark for a hook and loop fastener or hook and loop adhesive. Again, their company is fighting hard to make sure that they can keep their rights in that trademark. Now, hopefully, you at least have a little understanding of the difference in types of protection, maybe a little deeper understanding of patents, and then different ways you could use patents and different ways you could build a portfolio to achieve your overall goal. A few steps for you as you go forward after this webinar ends. You want to keep in mind the different types of protection out there and see what you can protect. See whether it makes sense to file for protection for a patent or a trademark, or if you want to file for protection for copyrights, which we didn't go over greatly, but it is another important type of intellectual property. Another one I can't stress enough is communicating with your engineers and sales teams, your overall objectives and strategies for protecting your intellectual property. It's something that often gets overlooked in small companies and large companies alike, where engineers and sales teams can be pretty eager to share information with others, share information with customers, and describe how great your company is, but don't always look to see whether there's a non-disclosure agreement or some other agreement in place, or whether you've filed for protection. Finally, communicate with your legal counsel if you have one, or if you need one, make sure that you do. Intellectual property has a lot of moving parts, lots changing in here, and different laws in every different country. Now I've included just some resources for you to look at your own leisure. McDonald Hopkins website, we often put up different articles and different podcasts discussing specific topics, intellectual property, and taking a little deeper look. USPTO.gov is the Patent Office's website. A lot of great information in there on the patent process and the trademark process. Another resource I put up is just a presentation that's given to jurors in patent litigation cases. It does a great job of explaining basic parts of patents and what it takes to prove somebody infringes a patent and what it takes to prove that a patent is invalid or valid. Finally, Google has a patent database. It's a free database that you could use to search through different patents, maybe search at your competitors, or see what else is out there. And I've included my contact information.
We do have one question that has come in. Can you give an example of something a business owner might be unsure of, whether or not they would need to file for protection or talk to an attorney about?
One that I run into often, I'll give two examples here of different scenarios where a business owner would be unsure whether they want to file protection. One is copyright or software in particular, whether they should try to file for protection for their whatever code that they've written. Important piece to know about patents is once you file for an application, that information will become public knowledge. So in the event that you're not successful in being granted a patent, whatever you disclose is going to be out there in the public. And once it's out there, you can't take it back. So you weigh the benefit of, if I disclose, my secret invention, I could be granted a very valuable patent, or I could just let all my competitors know what I've invented and maybe not be able to get a patent. Another aspect of that is code can also be copyrighted with the Patent Office. When you're dealing with developers and dealing with code, it changes a lot, it changes often. So you could file a copyright for every change if you wanted to. It's usually not cost effective. I know I usually advise clients that if they are making major changes and major releases and they're filing for copyright protection on their code, do the major releases. So do version 2, version 3, don't file a copyright for version 3.0.1.5 as an example. Finally, trademarks. It costs money to file trademarks and costs money to enforce trademarks. So business owners want to be aware of whether there's going to be value in filing for a trademark. If you're a business-to-business company, you make 300 different sizes of a product, you probably don't want to file a trademark for every 300 of those products. You might have a family of products that you have trademark for.
That concludes our webinar for today. So thank you again, everyone. And Mark, thank you for taking the time.
Thank you, Sean. Thanks, everyone.